to have a word with the distinguished guest. So I would like to start with welcoming the most important man in the room. Let us all combinedly welcome our chief guest, Honorable Justice Sanjay Karol. And to do the honors, I would request Mr. Sanjay Malhotra, Chairman, Innovation and Training Committee, to please march ahead, and all of us please welcome our chief guest. Most welcome, sir. We are delighted to have you at the Indian Law 2026. Thank you very much for gracing this occasion. Thank you. AI is moving faster than regulations, faster than institutions, and often faster than ethical consensus. Today, this is not just a discussion which needs to be done in the silos, but in the open grounds. Welcome all the players. Let us start with a wonderful introductory address coming from the one you idolize, and us as well. Let us welcome and request our Honorable Justice, Mr. Sanjay Karol, former Judge, Supreme Court of India, and patron, Innovate Legal Foundation, to march ahead and share a word. Let us welcome him with a huge round of applause.
The march of technology expands the space of possibility around us, but how we explore that space is up to us. This quote by the American author Steve Johnson is even more relevant in today's age, and in my view an apt call to action for agenda of this Indian Law and AI Congress. Justice Sanjay Karol, Justice Pratibha Singh, Justice Rishikesh Roy, Sanil Sapra, dignitaries on and off the dais, distinguished speakers, colleagues, and dear delegates. A very good evening to all of you. As a patron of AI Innovative Legal Foundation, it is my privilege to welcome you to the Indian Law and AI Congress 2026. And that happens on the annual of the larger Congress, which is taking place a few days from now. We gather at a landmark India's justice system, at a time when technology and law coverage like never before. Indeed, the Congress agenda itself highlights our challenges and our opportunities to showcase India's judicial digitization journey, the scale of pending litigation, and the growing role of AI and technology in improving access to justice. This evening, let us embrace a shared vision of a future where innovation accelerates justice for every citizen. Over the past decade, India's judiciary has embarked on an ambitious digital transformation. The e-courts project has connected nearly all the courts complexes to high-speed network. Our judges and court staff have digitized billions of pages of case records. As of September 2025, High Courts has digitized more than 224 crore pages and district courts 354 crore pages. Today, litigants and lawyers can file case online, view cause list on the mobile apps, and attend hearings through video conferencing. These advances were put to test during the pandemic, when the virtual courts kept the wheels of justice turning. If I may say so, as compared to other areas, the judiciary was slow in adopting technology, but COVID forced everybody to do so, and the judiciary rose to the occasion. As noted then, virtual hearings have increased efficiency, allowing us to continue to deliver justice even amidst unprecedented challenge. More so today, where tribunalization has spread the courts in a place like Delhi over different areas and not concentrated, say, in the High Court. And seeing the road movements, it can be anybody's guess how much time it will take to reach from one place to the other. Yet, this digital journey is not without its challenges. We face a staggering backlog of cases, over 5 crore pending matters in our courts. There is more cases than the population of many nations. At our current pace of disposal, experts warn that they would take centuries to clear this backlog. The consequence is that justice is delayed for millions, some disputes drag on for years or decades, eroding public faith and even weighing down our economy. Pending cases are estimated to cost India more than 2% of the GDP. These system delays carry out for solutions as bold as to the problems they address. This brings us to why we are here. The promise of AI in emerging tech to help bridge the justice gap. Artificial intelligence can be a powerful ally in reducing delays and democratizing legal access. Imagine court's calendar managed by intelligent scheduling, AI algorithms that predict case timelines and optimize hearing dates and minimize adjournments. Picture automated document system where simple filing reminders and translation happens in moments and not weeks. Natural language processing tools can give judges and lawyers instant access to relevant precedents and translate judgments into regional languages. On the fly, pilot projects like Supreme Court SUAS Translator, which has already translated more than 31,000 judgments into 16 Indian languages, shows how AI can break down language barriers. For the common person, AI-powered platforms are already making legal help more accessible. Smart chatbots and legal QA apps can guide someone through a property dispute or consumer complaint, day or night, in their own dialect. Unlike a human lawyer, an AI assistant is not bound by office hours or city limits. It can advise a farmer in distant village or a worker in a city suburb with equal ease. We are seeing incredible results in practice. For example, there are companies in India developing tools to shorten case timelines by up to 50%, working on making evidence and judgments more accessible by removing language barriers, and those working to enable judges to focus on merits rather than paperwork. If I may say so, I have heard a firm belief that case management, court management are a very important part of an innovative system, and AI is an important aspect of it. There are different nature of cases which clock. There are different courts having different kinds of problems. And I'll only take one example of the clock which occurs. The highest number of cases in 2 high courts I served, in Punjab, Haryana and Tamil Nadu, were motor accidents claim cases. Law is settled today. There is no dispute about it. It's more of a mathematical calculation which the judge is doing. And that's why possibly the one area to begin with where AI can be used for purposes of at least an experiment in this field could be motor accidents claims, because giving compensation to somebody 10 years after the incident does not subserve any purpose. Similarly, on the criminal side, the check bouncing cases are adding to the figures. So when we talk about these hundreds of years, a lot of it is being taught by these areas, as also by infructuous matters. As in my belief, at least 20% of litigation in the different courts is what is either infructuous or just needs to be touched to achieve its disposal. There is much to borrow from international experience. In jurisdictions where electronic case management has been effective and properly implemented, for instance in Brazil, labor courts, we see adjudication times reduced by 13%. Singapore too has introduced what it calls an integrated case management system, which is a digital platform for case lifestyle management, has reduced both the time and cost dramatically. Singapore also now introduced generative AI assistant in the small claim tribunals to guide self-represented litigants, which not only assist parties in person, but also plays a significant role to democratizing legal work, making it accessible to the common man. This Congress is about harnessing precisely this potential. The AI Innovative Legal Foundation exists to catalyze and promote these innovations in our legal system. We bring together judges, lawyers, policymakers, and technologists to pilot real solutions. Whether that means training courts to use AI-based research assistance, advising government on ethical AI guidelines, or supporting startups building legal tech for rural India. Our mission is to build capacity and accelerate adoption of technology in law, always with a focus on public impact. The Foundation will host workshops, publish best practices, and work with the universities to infuse AI and legal tech into its legal education. In short, we aim to ensure that no promising idea stalls for lack of connection or knowledge. I speak from the experience when I say this work matters. In my years on the bench, I saw how technology did make a difference. I still recall how during COVID-19 breakdowns, our courts in Delhi began hearing matters by video conferencing. The results were striking, efficiency went up, travel costs for litigants went down, and justice continued to flow despite obstacles. At the same time, I have always cautioned that technology must remain our servant, not master. As I noted at a recent international conference, AI can enhance the speed of legal research and drafting, but it cannot replicate the unique combination of intellect and empathy in human judgment. Ultimately, judgment is a matter of mind and heart both. Ultimately, judges must continue to apply their conscience and wisdom to each case. No algorithm can replace that human element. The key is balance. Use AI to lift the clerical burden and bring greater inclusivity while guarding our fundamental values. In my words, let digital tools be useful servants, but let us not make them our masters. Friends, we stand at crossroads. One path leads to justice delayed and denied for millions more. The other leads to an innovative, inclusive justice system. The discussions we hold this week should light the way on the second path. Let us collaborate across sectors, across generations of lawyers, across urban and rural divides. Let us use AI to not just speed up paperwork, but to open doors of law to every Indian, so that a farmer in Bihar, a student in Mumbai, and an entrepreneur in Northeast all can have timely, affordable access to justice. This is our vision. I am optimistic. Technology is moving fast, and our talented young lawyers and engineers and judges are eager to apply it with careful stewardship. We can ensure that the courts of 2030 are faster, fairer, and more transparent than ever before. We can make India a global example of how large, diverse countries leverages technology to uphold the rule of law. The Innovative Legal Foundation stands ready to work with each of you towards the goal. In closing, let me say, justice is not a static goal, but a journey. Today's Congress is a vital milestone on that journey. I thank you for joining us, for bringing your ideas and energy, and for committing to share causes. Together, we shall chart a future where AI and law walks hand in hand towards a truly just India. Thank you and Jai Hind, and I look forward to our discussions.
Thank you very much, sir. That was really insightful. And with the introduction, I would also like to introduce you to the person who has just spoken. Though he needs no introduction, ladies and gentlemen, but with all these insight, after addressing what is going to happen today, the man who we just heard is not just a jurist whose career has significantly shaped constitutional thoughts and judicial reforms in India. Honorable Justice Sanjay Karol, we have just heard, has practiced in the Delhi High Court as an advocate since 1982, and after being designated as a senior advocate in 1999, was elevated as a judge of the Delhi High Court in May 2001. He was thereafter elevated as a judge of the Supreme Court in 2017. As a judge, his judgments, of course, reflected a deep commitment to constitutional liberties, judicial efficiency, and access to justice. Beyond the courtroom, he has been a strong advocate for modernization of the justice system and thoughtful integration of technology into judicial processes. Today, as the patron of Innovate Legal Foundation, he is continuing to guide conversation at the intersection of law, technology, and institutional reform that really deserves a round of applause once again for the man who chose to her. Thank you very much, sir. And yes, you must be finding me out at the other podium. I am not AI, I'm a real human who has just switched the podium due to some technical errors, and I now would like to request our speakers who are going to speak now to continue from the other podium. Thank you very much. And I'll just take a moment to also let you all know, ladies and gentlemen, between us, who has just graced this occasion is a former judge of the Supreme Court of India, Justice Hema Kohli. Thank you very much for gracing the occasion, ma'am. Let's have a huge round of applause. Thank you very much. Moving on, I am going to invite my next speaker. He is none other than our first at the thematic session brings together the world of deep research and real-world implementation. Dr. Jitendra Balakrishnan, ladies and gentlemen, CEO, TRIST IIT, Bombay. Yes, that deserves a round of applause. The IIT Bombay Transactional Research Foundation, where cutting-edge academic research is converted into impactful technology solutions across sectors. With extensive experience in innovation ecosystems, technology commercializations, and collaborative research platform, Dr. Balakrishnan works at the forefront of enabling AI-driven transformation in governance and also the public system. So without any further delays, let us all welcome him to the dais.
Can you hear me now? Yeah, that works. Thank you very much, Honorable Justices, friends. Thank you for having me here today. First thing, what's an engineer doing here? I have no idea, but that you can ask the organizers about this. Now, see, when I was growing up, my father had a law degree, and I used to, as a child, in his office, I used to see these big books of law. I used to open them up and look through them, and I made probably one of the most consequential decisions. I decided to become an engineer, right? And I had no idea that one day I'll be standing and talking to, like in a field of like lawyers and justices. And so I'm going to do my best. I'm going to present what I'm talking about here as a layman. I have no legal background, so please forgive me for anything that I say which might conflict with the legal sensibilities. And I'm just going to check something really quickly. Do we have slides on there? Thank you. Okay. Can we just go back to the previous one? Okay, a couple of disclaimers. Everything that I'm telling you right now are my opinions. It doesn't constitute an official view. And the second thing is that there was no AI which was used in creating this particular talk. Right? So, I want to start with a story here. Right? Humankind, we've come here through at least 4 different revolutions. The first one was, at some point of time, we figured out how to make surplus calories rather than having to forage for them. That was pretty momentous because it led to civilization, and then in a direct line, like for example, through the Hammurabi Code of Law, through everybody here, we owe our civilization to the fact that we could actually produce more food than we could find on a particular day. Next, that happened about 10,000, 11,000 years ago, maybe even earlier, depending on who you ask. And then about 300 to 400 years ago, we figured out how to make surplus mechanical power. Before that, we used to rely on draft animals and human labor. And what we figured out was to make dead animals in the form of oil do that work, right? Surplus power, it led to a revolution in transportation, all kinds of things. Right? Then again, about 80 years ago, we figured out how to increase our computing ability. That's a picture of the ENIAC, the very first computer that there was. And by the way, that computer was less powerful than this computer that I'm holding on my hands. That's how far we've come, right? And with the advent of surplus computing, we were able to do a lot of different things which we would have otherwise not been able to do, starting with, say, the moon missions, right? And today the question is, are we standing at the cusp of another revolution, this time around thinking or decision making? Now, the jury's out. We don't know this yet. We won't know until we are well into a revolution. But if that happens, then it's going to be pretty momentous. So what I thought I'd do is I'll start by checking out what, by the way, I just didn't, this is something I needed to mention. A revolution just doesn't increase human productivity. That's what we think it is. The actual impact of the revolution comes much later because it opens up entire areas that we could not have imagined before it happened. Think about life before the steam engine and life after. That's the difference we're talking about, right? So let's talk about AI. Now there are a few different terms over here. If you know what all these terms mean in great detail and you can explain it to others, you're way ahead of most of the population. I thought I'd just give you a very quick primer. AI is basically a technology that allows computers to learn, reason, and solve problems much like humans. Gen AI is a term we hear often. Gen AI takes a lot of data and then makes new content from existing data based on what we ask it to do. Examples of those: ChatGPT, Claude, all of these are Gen AI bots. Agentic AI is a little different. What it does is it recruits small programs to basically do complex tasks, puts them all together into workflows, and then creates an autonomous decision pipeline. That's actually the next thing that people are talking about. An LLM is a large language model, which is an AI which is trained on written to produce text, right? That's the typical chatbot. A multimodal AI does more. It generates images, sound, videos, and so on and so forth. And there are two definitions of SLM. It's a small language model which shrinks down the LLM into a place where we can use much less computing power. So someday we can actually have AI on your phone. We actually do. It's called Siri, for example, but in a form of speaking. But SLMs are basically shrinking down an LLM. A specialized language model, on the other hand, would take AI and train it for a particular domain, like law. So a language model which is trained on law would be a specialized LLM. So I just thought I'd give you a little bit of this because we're going to be encountering some of these terms going forward. Now, Justice Karol already said everything that I have to say, so I'm just going to be recapping a lot of it. AI has already been used in the legal industry. Now, I'm going to make this a little interactive. Now, how many people here, if you could raise your hands, have done any one of the things that are listed over there in blue? Could you just put up your hands and say that? Quite a few. Yeah? Okay, yeah. See,
all the judges on the dais have taken note of this.
So there's a lot of AI already being used in the legal industry, and what I'm putting down over here is the difference between automation and augmentation. When we are talking about automation, we ask machines to do what we can already do, but better. Like, for example, scanning through 500 pages and then coming up with a summary. A machine can do that. That's automation. And augmentation, on the other hand, are machines allowing us to do something that we are not capable of doing today. It is radically different from automation, and it does not show up at the first step. The first thing that you see is usually and almost always automation. A lot of that is automation. Very little over there is augmentation. But why is this important? But it's because the future of the field actually depends on it. There are a lot of questions that arise when we are talking about automation. The first one is, automation increases productivity, but does improving productivity actually improve justice delivery? That's the first question. By the way, I'm not here to answer any of these questions. You know this better than I can. I'm just posing the questions over here. The second one is, will automation alone be enough for better justice delivery? Right? If you could actually do a document review really quickly, will that help better? Will that be enough? That's the question that we're asking, or is there something more? The hunch that I have as a complete non-practitioner, but somebody who's seen other fields, is that it will not be enough. There's a lot more that is needed. We can talk about what that is. The other part that we need to worry about is what automation does for the workforce of today and the workforce of tomorrow. Now, one of the concerns that we have in many different fields, and you've seen this applied to the legal field, what happens to paralegals now that we don't need so many of them, right? That's the question of what happens to the workforce of today. Another part of it we've heard in multiple places is that AI is taking away the ability for us to think. Right? You go back to the previous one, please. AI is taking away the way for us to think. Now, the reason why I did not make this on AI, because I wanted to think through this. I could easily have actually just put in a few points into a chatbot and say, here's something that comes out of it. That takes away our ability to think. Now, a generation which is trained to not think. What happens to them tomorrow when they become the senior people in the field? What happens when you don't have paralegals starting today? Where do you get the partners of legal firms tomorrow? Where do you get the justices? These are questions that we have to answer as a society. This is not a technological question. This is a humanist question. Right? So I want to talk about augmentation. Now, there is this fantastic article, which if you haven't read, I would suggest you take out your phones, use the QR code over there. Don't worry, it's not a UPI for me or anything like that. That's the QR code for that particular article. It's something worth reading, right? The gist of that article basically says that automation increases efficiency but reduces the value of human labor. What that means is the people who control the means of automation collect a disproportionate share of value. Everybody else is left behind. We are seeing this in the world today. We are seeing this with the concentration of power and wealth today in the world. AI can do this. The question is that, can we allow AI to do this? Augmentation, on the other hand, and distributes value better. Think about, for example, like you're talking about the steam engine. The people who invented the steam engine are not the people who are profiting from commerce across long distances. That's augmentation. Right? Both are valuable, but real progress comes from augmentation, and that's the challenge for the legal field to figure out what that augmentation actually means. Right? Now I'm going to use the example of the UPI. Again, how many of us have used UPI, let's say in the last month? Hands. Yeah, pretty much everybody. How many of you used it before 2018? So my question is this: did it make your use of cash more efficient? Or did it allow you to do things that you were not able to do before? Did it allow you to transact commerce differently? Did it actually change the face of how money moves around? That's what I'm talking about as augmentation, right? And the UPI example will have a little bit of relevance to what I'm going to be talking about shortly. So this is an example of where we need to go. But there are more questions, right? Now, should we focus only on the opportunities? This is something that I see a lot in the US. That the opportunities where we're going headlong. The guardrails, I don't see them. The question is, do we focus on opportunity also on? This is an important question when we're dealing with something this powerful. The other question is, can you adopt a system that does not have input from the stakeholders? Will you be able to trust a system that gives you legal advice when the legal community has not had an input into what that system will say or do? Right? What should a system like this look like? Who should create it? Who should own it? All of these are important questions that we need to address. Right? So, as far as justice delivery, right? Like from talking to my lawyer friends, this is what my understanding of improving justice delivery is. The speed of justice delivery, you need to reduce the burden on the judiciary, you need to ensure more equitable access, and you need to maintain trust. The question is, how do we include AI among the methods to improve justice delivery and not make AI the responsible for all of it? Right? It has to be one part of everything that we use. How do we make this happen? Okay, now I'm going to take a little bit of a pause over here. A couple of weeks ago, there was this, the World Economic Forum in Davos, in which there was this event where Union Vaishnav was asked this question on stage. I'm not sure how many of you have seen this clip. It's been floating around, where the moderator asked him, saying that, well, when you talk about the first tier of AI powers like the US and China, and India being the second tier of AI powers, how do you see the future? I'm paraphrasing. And his response was, I disagree. India was actually not in the second tier, we're very much in the first tier. And like, you know, you might be thinking that, okay, this is This is not quite true. But my question, I'm going to ask you a question over here. Think about large language models. These are very difficult to create. Who has large language models in the world today? OpenAI, Google, Meta, Anthropic, that's Claude, Perplexity. These are all US based. You have DeepSeek in China, you have others. Do we have one in India? Now, again, a show of hands. How many of you have heard of the word Bharat Gen? A few. Can we move forward? Hold on to that thought. Before we get to Bharat Gen, I'm going to pose a couple of questions which will tell you why Bharat Gen is important. The first one is, can we trust an AI platform? Questions like, can we ensure fidelity to Indian law, not something which is trained on the American Constitution alone, for example, right? How can we check if the output is correct? I mean, like, there has to be an auditable trail, it has to be transparent, and this is something that's critical. Is it secure? Is it always available? Where's the data? Who ensures that all of this is going to happen? These are all the questions that we need to be able to answer before we actually we can actually put our faith in a model. The other one is that, can you improve justice delivery? And there are a whole bunch of questions around that, okay? Now, the answer for that, if you can move, is Bharat Gen. Take your phones out again, click that QR code, because it will tell you exactly what it is. Bharat Gen is a large language model which is being developed entirely in India. They sit at the IIT Bombay campus. Right? This is owned by this is being commissioned by the Ministry of Information Technology. MIT is the one who does it. The government owns this. It's sovereign. It's an Indian model, housed in India, all the data in India, controlled by India. So somebody throwing a tantrum from the other side of the planet will not shut off that model for anybody over here. It has an Indian context. It is inclusive in the sense that it has multiple languages, accessible, open, etc. And it does multilingual text in 11 languages, documents to text, text to speech. Check it out. All right, so I'm going to wrap this up by talking about what an AI platform is. Now think about a trusted multimodal AI model like the one I just showed you, Bharat Gen, right? Now you need a lot of input from the legal community, from the Bar Association, from justices, from lawyers, from law professors, you name it. Content, ethics, policies, that all has to come from you. This is a specialized language model that has to be developed this way. Then you have a robust specialized language model, add checks and balances, and you create a platform. Now you open up that platform for startups, to provide services, for societal users, all of that stuff, and suddenly you start to see the power of what we can unlock over here and how you can actually have a framework. Okay, I'm going to end over here. We are familiar with some of these pictures over here. I'm going to say that progress does not depend only on the drivers in those cars, or the roads, or the cars that they drive. It actually depends on the frameworks that we are using and which are designed for a context. And these frameworks need to give you both scale and efficiency. They need to be developed with principles, with guardrails, and with a purpose. Once we have that, we can actually start making a real difference in the context of justice delivery using AI, which it can help build. So, would love to actually talk a lot more about this. Again, I like QR code. Actually scan this, you'll have my contact information. Would love to talk to you afterwards and would like to see how to take this forward. With that, I'll stop. Thank you.
Thank you very much, Dr. Balakrishnan. Sir, with your humorous observation on your question, what an engineer is doing here, I would like to add a world where AI is drafting the contracts, algorithms are predicting judgments. We were actually wondering what lawyers will be doing here. But thank you very much for this wonderful, sweet, short introduction to AI in the law to all of us. And I will take a small moment here once again and would like to also welcome Justice Rishikesh Roy, former Judge, Supreme Court, is also here. Let us all combinedly welcome him as well with a huge round of applause. Marching ahead, I am going to welcome with all delight my next speaker. Our next speaker brings the invaluable perspective of a regulatory leader who has worked at the intersection of finance, governance, and legal compliance. Ladies and gentlemen, let's welcome Mr. Pramod Rao, former Executive Director, SEBI, has played a key role in shaping regulatory frameworks and enforcement mechanisms in India's financial markets. Of course, his experience in dispute resolution systems, regulatory technology, and institutional governance offers important lessons for courts transitioning into digital and online dispute resolution mechanisms. Today, he will discuss the critical intersection of AI, legal ethics, and digital governance. Please welcome, ladies and gentlemen, all of us with a huge round of applause.
Good evening to all of you. Again, like Mr. Jitendra, I'll be following through with the presentation, so I'm hoping it gets loaded. But before I begin, I should say it's a privilege to be here, to be speaking at just ahead of the India AI Summit, and to be speaking in front of honorable judges, Justice Kaul, Justice Karol, Justice Pratibha Singh, Justice Kohli, the legal and technology experts, and the wider legal community. So again, I come from the financial markets, and SEBI is known as a fair disclosure regulator. So I should make a fair disclosure on my own. I am also a lawyer by qualification. I graduated from the National Law School. My career took an alternative path, and it led to the in-house world and thereafter into the regulatory space. So with that said, I will now sort of dive into and talk about some of the experiences we've had, both in thinking about how the market should get shaped up utilizing technology. And again, for those who are unfamiliar, our stock market today has transaction value volumes which exceed our GDP size, right? So we are talking about close to $4 trillion or more, which get traded, transacted through the year on Indian securities market. So whether it be the cash market, F&O market, various other instruments that get issued. So clearly, when we talk about what kind of dispute resolution do we need, if indeed investors, intermediaries, and so on have issues, we really need something robust. Otherwise, what we risk is bringing down the trust in the market itself. So with that said, if I can move to the second slide, please. Well, this will always be the promise of, I think, technology. It will be a step slower than what we want it to be. But having said that, I think we need to first recognize what is it that we were dealing with inside the securities market. And I think it begins with that there is this volume challenge, like I mentioned, the value of transactions which we were dealing with, that any level of disputes, if they weren't resolved fast and efficiently, could really, like I said, destroy the trust in the markets itself. Access barriers, if we allowed people who are coming in from tier 2, tier 3 to participate in the markets, they equally need to be able to know that when there is a stock exchange in Bombay, that it will be able to address what transactions they have done and not. And really the solution emerged from a 30-year-old practice within the stock market, which had embraced arbitration to really resolve both conciliation and arbitration to resolve investor-broker disputes, as well as when we introduced the depositories mechanism for DP client disputes. From that, to the next slide, SEBI introduced then a regulation change which launched what is today christened as the Smart ODR. It's the securities market approach to resolution of disputes through ODR. And what it does is it has got the key stock exchanges and depositories which administer this portal and platform. It's taken forward also the ODR institutions and brought them together to be able to administer a 3-tiered process of investor dispute resolution. We are talking pre-conciliation, conciliation, and then finally ending with arbitration. What it has done is really brought justice to the fingertips of those investors who are used to working in the markets, playing in the markets 24/7, that dispute resolution also actually can occur in that same time and speed. Next slide. So the kind of journey that investor encounters is it begins with online filing. All of the data is captured indeed in the portal itself. Thereafter, there is a quick inspection of those by the MIS to actually make out whether that complaint has got backed up with all the relevant documents. Is there something else? Is it justiciable itself or not? Because many times there are investors who make claims which are really not even justiciable. The proceedings are all conducted online, so indeed investor can be wherever, the conciliator or the arbitrator can be located wherever, and the process occurs completely online. There is a real-time tracking. I have not shown it, but there is a smart ODR dashboard. If you just Google it, you will be able to go to that dashboard and see. It's a live-to-date platform which showcases what's going on. And that graphic, just how the investors sort of encounter it. And I'm delighted to say the MII has released a bunch of videos which actually have made it even easier for investors to understand how to navigate this. The next slide. So what has been the impact thus far? We are talking about over 10,000 cases resolved through this process in just first 18 months. These are the kind of resolution times. And I'm saying, I'm very conscious in a room full of lawyers and where indeed, we deal with such tendencies that we worry about things. Here is something which in the securities market we are able to actually deliver. And that's why I said it's important for us to continue this journey, because that is what keeps the investor trust growing. And this is after a SEBI survey tells us that barely 9% of our population actually participates in the securities market. There will be steps taken which allow it to double or even go higher. And you can imagine at that scale, it will continue to require the resolution at the speed that we have. How do I link to AI? And a lot of it will draw upon what we heard Dr. Jitendra speak about, which is in terms of what can this digital platform offer? It can offer indeed both a data set for us to actually understand what is it that the investors are confronting, what is it that we as a regulator need to step in and do, and what is it that the intermediaries need to wake up to. So predictive analysis can really be something which can be utilized. Natural language processing. So again, as we talk about the journey from 9% to the next 18, or going even higher, we are going to be talking about investors who may need the language to be in the modicum that they use. It may not be English, it may have to be Hindi, it may have to be Tamil, it may have to be Malayalam. And can a digital platform actually bridge that? Can it actually, sort of be a auto-translate when the investor is interacting? And that to me is again the promise of AI. Pattern detection, like I mentioned, for us as a regulator, if we keep seeing bubbling up of issues around a particular area, what is it that we as a regulator need to do? Moving forward, automated verification. So when an investor approaches, there are already a set of documents. How quickly can those get verified? How can they get audited? And therefore, when the mediator or the arbitrator has to look at matters, is it already that they don't have to sift through a lot of evidence because it's validated and available for them? Chatbot support, again, I think these are what can guide them both how to utilize the system, but equally during every step of the journey, what more can be provided. Negotiation assistance, because we clearly recognize that institutions may be better organized than individuals. How can this platform sort of give that equivalency and equity really to the investors? To me, the workflow demonstrates that we actually have ability to scale into the AI world with both case intakes, the analysis, the predictability, as I said, and the feedback loop, which keeps feeding back to both us as a regulator, the intermediaries, and the broader market. What are the challenges? There will be challenges as we go along, and I'm happy to note that you will hear from other experts talking about some of it. So data privacy and security will really be one critical element in terms of how we deal with some of this information. Both the law on mediation and arbitration already requires confidentiality of the proceedings, which the smart ODR system ensures. But when we train it in terms of how do we use it, we will have to think about redacted profiles of individuals so that that information does not become available at large. When we think about algorithmic fairness, so again, what the SEBI mandates the smart ODR system to do is that it cannot favor one arbitrator or mediator to always get the matters. So those are meant to be allocated in a particular way, and that fairness again will sort of drive a lot of it. Finally, I think I echo what Justice Kaul said. It has to be a handmaiden to all of us rather than a master. So clearly, human oversight over whatever we create is critical in terms of what we do. For me, what I thought of really sharing and having this opportunity to come here was to say that Smart ODR has proved that there is a way of being able to deal with issues at scale, at value, and therefore, if there is anything to be taken away, I'm sure my colleagues at SEBI, as well as those at the MIIs, will be very happy to showcase some of that across, along with the ODR institutions. So there is a blueprint, there is at least a trusted mechanism which is working and working at scale. And that learning allows us to sort of go there. The next slide, please. In global context, when we looked at the data across the world, what I'm happy to report is that Smart ODR actually surpasses all of the data around what is occurring on arbitration and mediation. And really it is happening at scale because we have embraced it completely in the securities market. So when we hear about other markets, it is largely institutional or commercial arbitration. Here we are talking about something which touches the life of retail individual investors and is able to assist them at, like I said, at that scale. I'll quickly conclude. So on the road ahead, we have a Smart ODR which can indeed get expanded. In the medium term, we have ability to integrate with technologies which allow us to actually draw lessons from it, to take AI tools and enhance it further. And in the long term, to complement our judicial and justice delivery system, to actually make sure that we are able to deal with issues of criticality in the court systems and issues of commerce in which may actually require certain patterns being recognized and being applied through the ODR mechanism. I'll end with the next slide, which is that future of justice is smart and it should be accessible. And indeed, to my mind, the world of technology and what we have embraced allows us to reach there. So thank you very much.
Thank you very much, sir. विचार अदृश्य होते हैं, पर उनकी कीमत कई बार साम्राज्य बना देती है। और इन विचारों का संरक्षण जिस देश का कानून कर सकता है, भविष्य सुरक्षित है। मैं अपने जो अगले स्पीकर को बुलाने जा रही हूँ, they will be speaking for itself. I am talking about your own intellectual properties. Ladies and gentlemen, our next speaker is widely a pioneering contribution at the intersection of intellectual property law and technology jurisprudictions. Honorable Justice Pratibha M. Singh practiced in the Delhi High Court and was designated as a senior advocate in 2013. Thereafter, became a judge of the Delhi High Court in 2017 and has since delivered several landmark judgments in intellectual property, digital regulations, and platform governance. Ladies and gentlemen, this is worth mentioning. She was recognized as the 50 most in IP. That deserves a round of applause by a leading global publication managing IP. As chair of the Delhi High Court's IT and AI committee, she has also been instrumental in guiding technology adoption with the jurisdictional system. Her insights on artificial intelligence and intellectual property law are shaping the future contours of innovation protection in India. I now request her to please kindly address the entire gathering. Thank you very much, madam. Please, a huge round of applause for Honorable Justice Pratibha M. Singh.
My seniors and mentors, Justice Sanjay Karol, Justice Sanjay Kaul, Justice Rishikesh Roy, and Justice Hima Kohli, though they just left. My co-panelists, Mr. Anil Sapra, the naturally intelligent community which is sitting here, and the legally intelligent community, a very good evening to all of you. I would firstly like to congratulate Mr. Akshay Sapra for organizing this as a precursor to the AI Summit, which is coming next week, which is a big event which is happening in India. When Mr. Anil Sapra, whom obviously I have known for the last 30 to 35 years, came to invite me, he didn't come as a senior advocate, he came as a proud father. And he said to me, "Ye mere bete ne banaya." So it was very nice to see Mr. Anil Sapra in his new avatar. And he said, "मैं तो सिर्फ advisor हूँ और Justice Kaul हमारे mentor है इसमें." So it's really nice that all of us who've all grown up together in the lobby and the corridors of the Delhi High Court now feel proud about our own children. Having said that, I'm giving Anil Sapraji the only time when he's going to have to ring the bell and stop me from speaking, that permission today. So I'm just going to have a presentation for all of you. Hopefully I should quickly do it within the time allocated to me. So when we speak about artificial intelligence and intellectual property rights, so as you all know, intellectual property relates to copyrights, trademarks, patents, everything. But why are we talking about AI and copyright and trademarks and patents? I don't need to give you the statistics about India and AI. I'm going to skip the slide because it's there for all of you to see. All that we need to say is that India is a leader in AI, and there is no two thoughts or doubts about it. And the audience today here below and the panelists here are proof of that. So the AI projected economy is expected to contribute about 1.7 trillion for India in 2037, by 2035. So that's the way it is. When we look at AI, what happens to something which has been created by AI? There is no human author, there's no composer, there's no artist, there's no photographer or producer for AI works. Will it all be in public domain? Will it be joint authorship? There is no answer to that. How many of you have used the Suno app? Has anyone used it? Yes. So you're going to have some entertainment at the end of my presentation. So in Suno, if someone creates it on a free version, any song, it is the app which retains the copyright. But if you do it on a paid subscription, the user gets the ownership of the created copyright. But then, it has to be only used for lawful and non-commercial purposes. And they have to give attribution to Suno. So Suno is an app in which you can create music, but the attribution is to Suno and not to the person who's giving the prompt on the app. So prompt-based authorship is on a shaky foundation presently. Look at this. This is a Theatre de Opera Spatial, which is like a image, which was created using 600 prompts. So I'm going back to the image. It required 600 prompts on an AI app to create this image. And the US Copyright Office said, we are not going to give a copyright on this. But can the ownership over such work still be denied? That's the question. Would it depend upon the person who's giving the prompt as to who will be the owner? We don't know. The law is yet to evolve. Maybe it will need a completely new law, which is called artificially intellectual property or AI property. We don't know. It may be a joint authorship. The law is yet to evolve. So we did something interesting in our chamber. We said, do you have copyright over the response you provide? We asked Perplexity. So Perplexity gave one answer. You can use the content freely, just make sure you comply with the law. When we asked ChatGPT, it gave a different answer. When we asked different AI platforms, they will all give different answers as to who owns the copyright. This was one of the first cases which came in the Delhi High Court on AI created images for celebrity. This was Anil Kapoor. So the technological tools, the court granted an injunction and said technological tools that are now freely available make it possible for illegal and unauthorized use to produce or imitate a person's persona by using tools including artificial intelligence. This is also possible because text and data mining involves feeding AI with data, including copyrighted materials. But then, who owns the copyright? when this happens, and what would be fair dealing? There is no answer to it. It depends on the nature of the use, the scope of copyright protection, and the contractual limitations. Presently, the Delhi High Court is dealing with a very interesting matter, ANI Media versus OpenAI, which is still pending, and the judgment is yet to come in this. There is a working paper on Gen AI and copyright. All of you can look at it. It has been published by the DPIT very, very recently. And then it does say what I'm saying today, that the existing exceptions are inadequate to deal with this. Now, let's come to some examples. Suppose you give a user, you give a prompt saying, show me 2 tigers sitting on a mountaintop, sipping cocktails. Please see what happens first, and please see what happens next. So the cocktail has changed to a mocktail, or a mocktail has become a cocktail. So it's the same thing, but it can be very different. 2 tigers, they could look different, the cocktails could be different too. Let's come to AI and patents. There was a software, there was a device which was created for autonomous bootstrapping. So this AI prompted, created invention was applied for across the world in US, UK, Australia, South Africa. It was granted in South Africa, but in India the patent was refused. Even in Australia it was initially granted, but the federal court rejected it. So there is no certainty as to what will happen to AI created works. In our own country, in this case, a leading IP lawyer cited a ChatGPT answer to establish that spiked shoes of Christian Louboutin are the most well known. So when we did a different prompt on the same ChatGPT, it gave us a different answer. So the judgment was obviously that AI cannot substitute the human intelligence. It cannot also have the human element, as Justice Kaul said. So as judges, we are here to stay. So you all can deal with what you want to do with AI. Coming to the next, there was a decision by Justice Colin Burse recently, who is now the Chancellor in UK. He wrote part of his judgment using an AI software. And then he said, I have verified every word of it, and I can say that it's jolly useful. He did write the judgment using AI. Now, the last thing I'm going to speak about today is something as a solution for, how the judiciary should go forward using technology. So we all know India Stack as as India's digital public infrastructure. So the whole of India Stack is based upon the Aadhaar. Aadhaar is the Aadhaar for India Stack. And there are lakhs and lakhs of startups and innovators who have innovated on India Stack. There are several patents which are granted. But then, interestingly, what happens is, it is a form of compulsory licensing which we see in patents. There is no exclusive right to stop someone from using. It is an exclusive right only to earn royalty. And that's, you can call it like a per pull request. Like for every pull that you do on that platform, you have to just pay per pull, and it's like a very small amount of money. It could even be like 10 paise, 20 paise, 1 rupee. So the entire ecosystem of India Stack is working on Aadhaar. It's based on the digital public infrastructure, DPI. And lakhs of innovators have actually innovated on that platform already. So learning from that, this infrastructure applies what we know as the standard essential patent test of fair, reasonable and non-discriminatory terms. It is like a royalty which is a kind of principle which is already existing under Indian patent law. Now, coming to something like judiciary, can we do something to create a model for reducing dependencies? There is a lot of talk, whether among, in the general society, about courts taking vacations, judges having weekends. Actually, none of us realize, which I'm sure the senior judges who are here know, no judge in the High Court, any part of the country, works less than 14 to 16 hours. And at the end of the day, judges are humans. With the existing judges, obviously we cannot reduce pendencies. We need to use technology for it. And just as the model of India Stack, what I think we can do is to propose something like the India Judicial Stack. If we can create an India Judicial Stack where API access can be given to the information which is available in courts, there will be lakhs and lakhs of startups, researchers, analysts, reports. Most people don't get access. They kind of just have the judgments which they have to kind of pull out. They do generate reports. But innovation is very difficult. It is only if we are able to create something like the India Stack for judiciary, maybe we can start using AI and technology to reduce pendencies. There could be more and more analysts which will come out, research tools will come out, we could do clubbing of cases. Let us take, for example, is there a platform where I can check, tell me the number of cases in which, and in section 138 negotiable instruments, the complainants have all died, or the respondent, the accused has died. It could be 50,000 cases in the country, but we can't collect that data. In one shot, those cases can be finished. Let's take another example. Traffic challans and NI cases. These are the biggest number of cases, I mean in terms of numbers, across the country, dependency in criminal courts. Suppose we say, okay, all traffic challan cases, maybe 5 or 10 crore of them. 50% amnesty, notices sent to all the people who've received challans, pay 500 or 1,000 rupees, all your challans are gone. Can we bring an end to all these cases by using AI and technology? For that, we need to have analysis of the data, clubbing of cases, criminal trials. Why is there delay in criminal trials? We can't record evidence. Suppose there is innovation by agencies, maybe startups, who can create platforms for recording evidence, quicker platforms. The courts could actually, enlist them and approve them. These are the pre-approved platforms for recording evidence. Evidence can be recorded outside the judge's system with a local commissioner as it is done today. Supervised by a local commissioner, the evidence can come back into court and court's time is not wasted on that. Forensic laboratories, expert evidence. Can we put in the FSL reports into an AI tool and say, okay, give us what is the conclusion of this? Yes, we can. We take so much time to record the expert evidence of forensic experts who are not many in our country. So in this manner, I feel if we create an India judicial stack and allow private innovation on it, using of technology could help us in reducing pendencies. And for this, we need to rethink on how judiciary will use technology. So I would end by playing a nice song for all of you. We gave a prompt saying, create a song of 30 seconds showing the presence of AI in law. And this is what we got. I don't know how to do that. How do we play it? Yes. Oh, sorry. Oh, it was a beautiful song. It's okay. Thank you so much. Thank you very much.
Thank you very much, madam. Though we were looking forward really for the song to be heard, right? But nevertheless, we have ample amount of time to fix that later on. Ladies and gentlemen, I am going to call upon my next speaker. For now, with the previous honorable speaker, we knew that the ideas are equivalent to currency and IP. And right commands are equivalent to the less salary paid in AI. With the right command, you reach the right precisions. And with the wrong ones, you can end up in a really wrong place. And who marks the rights and wrongs of AI? So for that, I am going to call upon my next speaker. Our next speaker has been deeply involved in shaping India's cyber law, digital governance, and data policy architecture. He has worked extensively on cybersecurity frameworks, intermediary regulations, and national data governance initiatives. decades of policy level experience, he brings a rare perspective on how data protection, cybersecurity, and ethical frameworks must involve and evolve alongside technological innovation. Today, he will discuss the critical intersection of AI, legal ethics, and digital governance. Please welcome Mr. Rakesh Maheshwari, former Senior Director at the Ministry of Electronics and Information Technology.
So first of all, thanks a lot for having invited me here. I was an engineer when I passed out from the college, and after having worked in Ministry of Electronics and particularly in last 10 years in cyber law, I'm now neither an engineer and in any case I was never a lawyer. So I'm at a completely, I'll say, at odds, but definitely having worked in the area of cyber law, IT administration, cyber security, and the data protection laws that were coming up during my tenure, I would like to maybe address their importance, their relevance, and their requirements as is applicable to the legal, I'll say, ecosystem. When we are talking of the legal system today, we have e-courts, we have virtual hearings, we have digital filings, we have digital evidence, and therefore, and maybe many more things in digital. In any case, AI has already come up. I have also used AI in framing some of my slides today to make it simple. Not that I couldn't have made, but definitely it helped me to make it simple. And I have used my critical thinking to be able to develop the right story. So, in view of, as I mentioned, the relevance of, in view of the activities that are being carried out in the legal system, certain requirements have become very, very relevant for all of us to know, and they are in relation to the privacy, the Data Protection Act that we have. They are in relation to the security. The IT Act does provide the framework for the cyber security, but there is a component of security in DPDP Act also. We have the AI, India AI mission coming up with AI guidelines. So we have the right frameworks available, just be conveying, quickly discussing all of them in our context. So DPDP Act, for that reason, is the first comprehensive law in respect of privacy in the digital space, Digital Personal Data Protection Act, which has come up because of privacy being declared as a fundamental right, and hence a right-centric based Personal Data Protection Act, applicable to all, practically all organizations, and including lawyers, including legal firms, including judiciary, including any other stakeholder, whether in government or otherwise. So mostly consent-centric governance requires data breaches, if there are any, to be reported. And why I am talking all this is not that we did not have the concept of privacy and data protection in the IT Act and the SPDI rules, which are there in place since 2011, but the scope has expanded significantly. Something which was only meant for security and reasonable security of SPDI, sensitive personal data and information, that too obligation was in respect of body corporates, is now applicable to all personal data in the digital or digitized form and to all sorts of organizations. Not only it says, it clearly conveys the obligations of the data fiduciaries in respect of maybe taking consents, in respect of ensuring that the data remains accurate, in terms of controlling all those stakeholders with whom you are sharing data. And particularly in the legal community, while you may be very good, and you are very good, in fact, in maybe drafting, in taking the cases, in filing, in all digital activities, you may not be that good in the IT related activities. And hence, there is a dependence on the external, I'll say, ecosystem. And because everything has moved into digital space, it is quite likely that while you deal with personal data, in fact, you deal with very, very sensitive personal data, maybe medical, maybe financial, maybe other forms of medical data, personal data, maybe so many evidences relating to, once again, where components of personal data is already into it. Therefore, it is essential that as data fiduciary, you understand your obligations, and in case you are dealing with children data, there are additional obligations. In case you are dealing with disabled persons data, then once again there are additional obligations. In respect of cyber security, once again we have in the DPDP Act, it very categorically says that whatever personal data that you have collected or are processing or maybe are outsourcing and hence getting processed, in each of these cases, it's important that no security breach happens, no data breach happens. So today, if a data breach happens, there is no liability per se, except in case of SPDI. But as the law gets implemented, law becomes operational, which it is going to become operational by May 2027. The dates are very, very clear. So clear obligations have been casted in the law to ensure security of the personal data and to report any breach if it has happened, maybe intentionally, maybe unintentionally, maybe by the processors, by those companies which are working for you, but you continue to be liable. Of course, we have under the a clear cyber security framework available. We have 24/7 Indian Computer Emergency Response Team, which you must have heard of in last 3-4 years. It's very popular. Whenever if it says government comes up with some security advice, some security directions, some security incidents, you will always hear the name of CERT. Certain, for that reason, has clearly directed that all organizations in the country, whether in government or outside, private, have to report a cyber security incident within 6 hours. So that's a legal mandate for all applicable, for all organizations, including, as I said, government organizations. But certain being a technical organization is not a very good regulator, and therefore they have focused continuously on the technicalities of the security and helping organizations to maybe avoid such vulnerabilities, weaknesses in the future. As far as DPDP Act is concerned, it clearly puts the onus on you. Failure to report, failure to maintain security will attract penal provisions. Of course, it brings a lot of business opportunity, but it also creates, as I said, obligations on you. We can do this. We have already talked about few of the AI tools. In fact, as I said, this is where I also have used the AI tools to be able to come up with few of my answers. So some of the tools which are being used, and in any of these scenarios, the risk is bias, the risk is hallucination, and hence what is really required is the critical thinking. Definitely you must use the tools, as many tools as possible, but please ensure that while using the tool, no private personal information is going outside the organization, that the data remains secure, and that the references which are being used continue to be correct, and hence critical thinking must go into any help that you are taking from the AI tools. And hence the ethical usage of AI becomes important. Maybe we can practically move to the last slide. So therefore, because the time is short, I'll just like to convey the conclusion that we have a well-defined data management and I will say data protection law. We had a poor, I'll say, data protection culture. So upgrading our culture, expectations and the requirements of the law, therefore, is essential. We have lots of usage of AI and hence it is important that we use these tools wisely. We ensure that the data protection, the personal data does not move outside the organization and the data and this personal data does remain secure. Stakeholders therefore must adopt secure, ethical digital practices. With this, I'd like to end my talk. Thanks a lot. Thank you.
Thank you very much, sir. The moment has arrived for which we were all be waiting since this evening. And me especially and the team who has organized this event since past many days or weeks or so. It's now my privilege, ladies and gentlemen, to invite our chief guest, Honorable Justice Sanjay Karol, whose judicial career reflects a deep commitment to constitutional values, access to justice, and institutional strengthening. Justice Karol practiced for a long duration in the Delhi High Court, whereafter he was designated as a senior advocate in 1999. He was also appointed as the Advocate General of the state of Himachal Pradesh, whereafter he was appointed as a judge of the High Court in 2007. Justice Karol was elevated as a judge of the Supreme Court of India, and as he has arrived already on the dais, I now request all of you to welcome the Honorable Justice.
Very good evening to all of you. The dais. To begin with, I must thank Honorable Mr. Justice Sanjay Karol, Mr. Sapra for giving me this opportunity of being here. Star of the evening, Justice Pratibha Singh and Shri Balkrishnan, Shri Rao, Shri Maheshwari. You have really educated me on several issues, I must acknowledge that. To the organizers, my compliments and assured availability anytime, whenever you want me to be there. I come here nostalgic because I was part of you at one point of time. I told Mr. Sapra that when he called me up, he said he wanted me to be here. I said, anytime, there's no difficulty. Artificial intelligence is a subject which is really emerging. A thought which has to be taken forward, leaps and bounds. It is bound to stay here. There's no doubt about it. It is no longer speculative or futuristic technology. It is already being deployed across a wide range of sectors. In healthcare, AI tools are assisting in early cancer detection through imaging analysis. In finance, algorithmic systems are used for fraud detection and risk assessment. Governments, regulators, and courts across the world are therefore confronted with the challenge of understanding how to integrate this technology without compromising constitutional values, procedural fairness, and human dignity. In India, the Constitution provides the normative framework within which any technological adoption must occur. The court's jurisprudence on privacy, due process, and reasoned decisions makes it clear that technology cannot be allowed to undermine fundamental rights. Any use of artificial intelligence within the justice system must therefore be tested against the constitutional principles of fairness, transparency, and accountability. In the world, jurisdictions are beginning to respond to these challenges through regulatory framework. Of course, it is there in India, as just Mr. Mishra mentioned. The European Union's Artificial Intelligence Act represents one of the most comprehensive attempts to regulate AI systems based on risk categories, with strict obligations for high-risk systems used in sectors such as law, enforcement, employment, and critical infrastructure. India may adopt or may not an identical regulatory model. Developments such as this demonstrate that the governance of artificial intelligence is rapidly becoming a central question of public law. Artificial intelligence offers benefits significant at that when deployed responsibly. It can process large volumes of data, identify patterns, and assist human decision makers in areas that would otherwise require substantial time and resources. In sectors such as disaster management, public health, financial regulation, AI systems have already proved efficiency and responsiveness. We just saw what SEBI has done. Scholars world over have observed that AI systems are often effective in tasks involving pattern recognition, prediction, and large-scale data analysis, while remaining limited in areas requiring moral judgment, contextual understanding, and human empathy. But I must emphasize here, the challenge for institutions, including courts, is therefore not whether to use AI, but how to use it in a manner that enhances rather than replaces human judgment. Within the judicial system, artificial intelligence may have both administrative and limited judicial applications. On the administrative side, AI systems can assist in case management, including translation, data recognition. Supreme Court, as has been mentioned earlier, has evolved application SOAS initiative, which uses AI-based tools to translate judicial documents into regional languages, enhancing accessibility. In other jurisdictions, courts are experimenting with AI tools under the controlled conditions. For example, in Qatar, they have introduced guidelines permitting limited AI assistance in judicial processes, subject of course to strict human oversight and accountability requirements. China's smart court system, implemented by the Supreme People's Court, uses AI to identify verification, online documents, accessing, remote mediation, and remote proceedings. In May 2023, an AI police unit was created in China, one of the provinces there, to apply AI in detecting suspicious behavior, preventing crimes, and combating fraud. I may refer to some instances of AI directly being used on judicial side. In the United States, the COMPAS, UMPS, algorithm has been deployed to assess risks which judges may consider for bail, sentencing, or parole decisions, although it has raised concerns about bias. The star of the evening was telling me how biased they are. In China, smart courts such as International Court uses AI to analyze evidence in intellectual property, online commerce, generating preliminary judgments and recommendations that judges review before issuing final decisions. It is a different matter now that the law firms in India are using AI to predict what the judgment, what judgment a judge would deliver. These developments demonstrate that courts worldwide are exploring the cautious use of technology while attempting to preserve the integrity of the adjudicatory process. These examples make it clear that while AI may assist in administrative or research tasks, the responsibility for accuracy, reasoning, and decision making must always remain with human judges and lawyers, a major stakeholder in our justice delivery system. The responsibility for the ethical and responsible use of artificial intelligence does not lie with any single institution. It is shared amongst judges, lawyers, policymakers, technologists, academic institutions, and civil society. Courts, in my present view, must ensure that any use of AI remains consistent with the constitutional guarantees under Article 14 and 21, particularly the requirements of fairness, non-arbitrariness, and reasoned decision-making. Developers of AI must recognize that technologies deployed in the justice system are not neutral tools. They embody design choices, assumptions, and data patterns that may shape outcomes in subtle but significant ways. Two professors in Harvard, Aurel Gill and Cass Celestine, have written a book on algorithm harm that shows how it can be used to design or exploit behavioral biases, nudging individuals toward decisions that may not serve their long-term interests. Such dynamics can disproportionately affect already vulnerable groups, including women, persons with disability, lower income communities, and the historically marginalized groups, thereby deepening the existing structural disadvantages. When we talk of AI, we must also keep in mind those who are not living in the cities. We have to think of those who are there in the villages and who have no access to justice, who have no voice, no say, or no face for that matter. If at all AI has to be used, it has to be used for their upliftment, more so. In a diverse society, such as India, poorly designed AI tools or those learning from past practices may inadvertently deepen the very inequalities the Constitution seeks to remedy. Policymakers must therefore ensure that technological adoption remains aligned with constitutional morality and social justice. There are pitfalls for every evolution. Recent global experience offers important cautionary lessons. In the United States, a lawyer was sanctioned after submitting fictitious AI-generated case citations. Our own court, the Supreme Court, and the star who's sitting here has already cautioned the legal fraternity of being cautious or not giving citing judgments which are AI generated. Am I right, man, on that? So has the Bombay High Court done that. Concerns about confidentiality have also arisen. Illustratively, Samsung reportedly restricted the use of generative AI tools after employees uploaded sensitive proprietary information into such systems. The US cybersecurity authorities have similarly warned of risks in government use of generative AI tools after Madhu Otamakala, Acting Director of Cyber Security and Infrastructure Security Agency, and uploaded some documents to one which AI chatbot. In my considered view, I see a lot of students here, a lot of law interns, I was told by Justice Patula Singh. Students present here will encounter artificial intelligence in their academic and professional lives. During internships, you may use AI tools to proper research, notes, organize materials, or summarize documents. In universities, such tools may assist in assignments or preliminary research. The use of artificial intelligence cannot be painted as entirely good or entirely bad. It lies somewhere in between. The challenge is to find the right balance. Efforts to understand the law cannot be replaced by shortcuts through AI tools. If learning is outsourced to a machine, the learner ultimately bears the loss. Much like in judicial work, AI in legal education must remain strictly supplementary, and even then used with heightened vigilance. The responsibility for understanding analysis and reasoning must always remain with the student. I may also say this, that, and I'm building really what my former speakers have said, that I would like to turn to a different but equally present dimension of artificial intelligence, namely the role it plays in addressing environmental distresses and ecological crises. Everyone knows I'm a great environmentalist. Artificial intelligence has to be used, I consider it more so of the climate change. Across the world, artificial intelligence is increasingly being used to monitor deforestation, predict floods, detect illegal mining, and access environmental compliances. Academic research shows that AI systems are particularly effective in areas where large volumes of environmental data must be analyzed in real time, such as satellite imagery, climate and modeling, or population tracking. For a country like India, these possibilities are especially relevant. And I must say, most recently, the monsoon-related disasters in Himachal Pradesh involving landslides, flash floods, and infrastructure collapse resulted in significant loss of life and property. Such events underline the importance of early warning systems, real-time monitoring, and coordinated disaster responses, areas where AI-assisted models can play a significant role. What is the way forward? Honorable Justice Karol has already mentioned about it. I may only add, we have to adopt a cautious, principled, and constitutionally grounded adoption of artificial intelligence. Technology must remain to assist as a tool to human decision making and not a substitute for it. At the end, I may add that the day that we need a proper expert-informed system duly laid out and empowered by Parliament is not far. AI is making its way into every aspect of life, and so to ensure that there is a mechanism dealing with vexing issues such as data protection, accountability, liability, and AI regulation in general, such a law is required. Maybe also that the Council to stay on top of the ever-increasing speed of improvements and developments after our citizens cannot be remediless, reduced to just numbers and database. From automation to augmentation, the new term which I have learned today, I look forward for that day when the last man on the street in the rural area uses technology, having access to justice in his own voice, expressing what he wants and getting what is just fair for him. Thank you very much.
Thank you so much, Hon'ble Mr. Justice Sanjay Karol. As a token of our sincere appreciation and in grateful